morning. This case, I'm assuming you're all here for Kearney versus Campbell. Each side will have 15 minutes, so that means that the two appellees will have to divide the time. And the appellant may reserve up to 5 minutes, and we're ready to proceed. If you don't mind coming up here, that would be nice. We do that just to, it's like,
So
have you ever seen that show on TV, The Idiot Test? It cracks me up.
I lost that.
I lost many times. All right. Would you like to reserve some time?
Yes, I would.
Is there still a sign back there? There should be. I hope there is. I don't know.
On the podium there is, yes.
Okay. All right. We'll have to make that, because everybody does that. Everybody does that. Okay. You're fine.
With the court's permission, I'd like to reserve 3 minutes for the
That's fine.
The present case presents an opportunity for the court to further explain and explore 3 distinct issues under Ohio law. The first being standing, the second issue being interest, and the third issue being real party interest. And I think the key in this particular case is the distinction between interest and real party interest.
Excuse me, Counsel.
Yes.
I thought I was 16, but I didn't hear you introduce yourself.
Oh, I apologize. Chris Van Larkin, counsel for appellant.
I got him all worked up, so.
It's your fault.
It's my fault. Go ahead.
The Ohio law on these particular issues is currently in flux, as evidenced by a recent Supreme Court decision in Kupta, which full citation is Bank of America versus Kupta, which was decided last October. In that particular case, the Supreme Court clarified its prior decision in Federal Home Loan Mortgage Corporation versus Schwartzwald, which was a critical case for both the 6th District's decision in Shefku, as well as the trial court's decision in this particular case. Kearney, in this particular case, respectfully submits that the trial court and the 6th District misinterpreted the holding in Schwartzwald, and in particular the concepts of interest and real party interest, in the holding that Civil Rule 17 could not allow a substitution that relates back to the original date of filing, where it was a situation of a real party in interest who had also an interest in the case. Further, the decision in the 6th District is not only the minority opinion in the entire state, but it would also, its adoption in this state would place Ohio in the extreme minority of all states, which have found that the bankruptcy trustee in cases, the substitution for the original debtor after the statute of limitations relates back to the date of filing. Lastly, adoption of the Shefku decision by this court and other courts in the state would allow procedural maneuvering by defendants in the case to avoid debts by waiting until the statute of limitations expires and then filing a motion to dismiss. In fact, in this particular case, the defendants were put on notice that the debtor declared bankruptcy 2 years before they filed their motion to dismiss by way of deposition. And looking back at the issue of standing, in Kupta, the Supreme Court made an important distinction from its prior decision in Schwartzwald by indicating that standing is not an issue of subject matter jurisdiction, but rather a prerequisite for the court to exercise jurisdiction. That's important because it is not an issue where the case was void ab initio, but rather the lack of standing made any decision in that particular case voidable after the fact. That's one of the primary distinctions that was in Schwartzwald, but in looking at it, there was a much different fact pattern in that particular case than this case. In that case, what had happened was a party who was trying to foreclose on a mortgage did not have the interest in the mortgage at the time they filed suit. After they filed suit, and after the statute of limitations ran, they received an assignment of the right to pursue that foreclosure action, and then attempted to substitute themselves back in with their assignment to relate back to the date. And the Supreme Court rejected that. In looking at that particular case, that's a case where we're missing the initial interest, not the real party interest, again, it's distinguishable, but they did not have an interest in the particular case. In looking at standing, we have as a primary requirement that you have an interest in litigation, the outcome of the litigation, because if you do not have that, you do not have a judicial controversy between the parties that can come before the court, and therefore there's a lack of standing. But to say that a party has interest does not mean that they necessarily have standing. There's another side facet of standing, which is where there has been a ruling or a enactment which says that the party who's bringing the suit must have a legal capacity to bring that action as well. And we see that most frequently in bankruptcy cases as well as probate cases where the individual has to have the authority to proceed on that particular action. In fact, this court and other courts have distinguished between constitutional standing versus prudential standing. And prudential standing being the situation where the party does not have, where's the question of whether the party has a real party in interest, where the constitutional standing is where the party has some type of interest in the matters on the property. The reason why that distinction is important is because the Schwartzwald decision was clearly on point with the constitutional facet of the standing issue. The party had no interest in the litigation from the outset. They couldn't bootstrap back in and create that interest.
Let me ask you, how do you overcome that in this case where in bankruptcy law, if you don't claim that when you lay out assets, that you didn't claim it existed at that time, so how do you overcome that?
Again, going back to the distinction between interest and real party interest, the first question is if the assets were not disclosed, the asset that was not disclosed, it still belongs to the bankruptcy trustee. The bankruptcy trustee is the real party in interest. That doesn't eliminate the fact that the individual is held in the right, as held in several decisions in Ohio, and what was said in our brief, that the bankrupt party, the debtor, still has an interest in the outcome of the bankruptcy litigation because they have an exemption, and they also were entitled to any monies over the amount. There's also an issue that hasn't been determined in this particular case, and in most bankruptcy cases, whether the failure to report was the fault of the individual debtor or the attorney. Therefore,
But isn't the interest speculative?
it is speculative in the sense that he may never recover, but that does not deprive the court of the subject matter jurisdiction of the interest part of the case or the standing. There has to be a determination later on that there's still some unity of interest with the bankruptcy trustee in getting a successful resolution to the case so that there is a pot of money to be divided between the creditors as well as anything that will be left over for the bankrupt debtor. What is developed in Ohio law, though, and again, is that Rule 17 specifically talks about real party and interest. It distinguishes between, it doesn't say interest, the party and interest, it says the real party and interest, someone with a legal requirement. And at the end of that, it says that when you substitute the real party and interest, it relates back to the date of the original filing. That is what the purpose of that particular rule is, and it's not in conflict with Schwartzwald, which is talking about that interest, that constitutional interest necessary to go forward on the case.
But there is statutory time.
Correct. Yes, the statutory.
Overcome as well.
But if you take that out, what purpose does the relate back section at the end of Civil Rule 17 have? Because if there was still time remaining, you would need the relation back. The relation back only happens as if you run out of time.
Well,
Because
you said that Rule 17 says that it relates back in time, but what it really says is that in any ratification, joint, or substitution shall have the same effect as if the action had been commenced in the name of the real party in interest, not at the time that it was commenced. It doesn't really address time at all. It sounds as if it's putting you in the place so that you would have the same rights as the party that brought it.
Then there's I guess, the distinction between why it would be necessary to have that language. I agree that doesn't say specifically commence back at the time, but I think that's implied because if we were to assume that it didn't, there would be no need again because you could just add that party and then join as a party and as another party to the action. And that's not what the other courts outside of Ohio or the Ohio appellate districts have ruled. They have considered it going back to the date of commencement of the suit. And that is the majority of opinions in Ohio outside of the Shepherd decision, as well as outside of the state. And going back to that, we've cited a number of cases outside in the state as well as outside of the state, which have similar fact scenarios and deal with similar civil rules, including ones outside of Ohio, including federal courts and other states that have the relation back language at the end of their version of Rule 17. And they've almost unanimously found that it does relate back to the date of commencement. There is no bar by the statute of limitations. Accordingly, since we see that there is a distinction, we respectfully submit that Rule 17 did apply in this particular case. That should have related back to the date of filing and the court should have allowed the bankruptcy trustee to substitute themselves for the debtor in this particular case. The only parties that are actually harmed by this, if they're left out and the case doesn't continue, is the innocent creditors of the debtor. It's not the debtor who's going to suffer, it's going to be the creditors of the debtor. Whereas if this is allowed and the substitution goes back, the defendants have had full knowledge of this case for its entire life, and there's not any prejudice there defending against the new party.
How do you respond to the argument made by the appellee that to hold, as you are asking us to do, really rewards individuals who fail to disclose assets in bankruptcy and then later, oh, by the way, I had this claim. And so, you know, you only get in trouble if you get caught.
There's a separate concept called judicial estoppel, which would stop the bankrupt debtor if he, in fact, attempted to deceive the bankruptcy court from collecting anything. It can be enforced in the trial court if the court finds that there was a deception on the part of the individual. It can be enforced, and it is regularly enforced in the bankruptcy court if the bankruptcy court feels that the debtor purposefully misled the court. So this is a step before we get to the idea of judicial estoppel. Mr. Kearney may very well be judicially stopped from collecting recovering his monies in this case for the exemption or anything over that amount. People who are really harmed in this are the creditors of Mr. Kearney, who had no part in filing the petition, had no knowledge of this case until it was brought to their attention. In closing, we would ask the court find that there is no bar or statute of limitations for the trustee to substitute in, to find that the trial court erred in refusing to grant the trustee sufficient time to file a motion to substitute, and remand back with instructions to allow the substitution. If there are any further questions.
I don't believe so. Thank you.
May it please the court, counsel. My name is Victoria Bartow, and I am here to argue on behalf of Appellee State Auto, and I will also submit to the court that the interests of the appellees are fairly well aligned. So I have spoken with my co-counsel, and we've agreed that I'm going to take about 12 minutes, and we'll reserve about 3 for my co-appellees to address any issues that I may not raise before the court. I would also ask for the court's understanding that I have my cell phone because we don't have a timer here, so this is what I'm going to use to kind of keep track of my time. That's fine. And I also apologize for not buttoning my coat, but it's not buttoning. So, may it please the court. We are here today to talk about standing and interest in real party and interest. Unfortunately, this court already has a decision from the Ohio Supreme Court, and we also already have decisions out of the 9th Appellate District that lead this court to the conclusion that it needs to affirm the ruling of the trial court and find that Mr. Kearney did not have standing to bring his lawsuit, and also that the time is barred and the case can't be pursued by the bankruptcy trustee. As this court is aware, this case arises out of an auto accident that occurred in May of 2010. After the auto accident, the plaintiff filed for bankruptcy. The bankruptcy was discharged. And one thing that the court needs to note, and keep in mind throughout the argument, is there's no dispute that the plaintiff did not disclose in the bankruptcy that he had this personal injury asset. And that's going to be key, because you heard appellant's counsel speaking about an interest versus a real party and interest versus standing. The reason that the plaintiffs in some of the cases that he cited had an interest at all was because he disclosed his asset in the bankruptcy. That didn't happen here. And because that didn't happen here, the plaintiff does not have standing, he does not have an interest, he's not the real party of interest, and he can't pursue the claim, and it's now time barred. After the debt was discharged, the plaintiff filed his personal injury suit. You heard some reference to the fact that the appellants were made aware of the bankruptcy during the trial court proceeding. That is in fact true. We did learn about it during the deposition, and I will represent to the court that while it wasn't raised, we pursued information about the bankruptcy, and it was never turned over. It wasn't until very late in the game when someone had to go out and get permission to access the bankruptcy court's docket that we learned all of the information that led to the subsequent filing of the summary judgment motion. But there's no dispute that the bankruptcy trustee was not a party plaintiff at the time that the civil lawsuit was filed. So the issues that the court needs to consider now is whether the plaintiff can substitute the trustee as the real party in interest, and whether the plaintiff actually had standing or any interest in the case when he originally commenced it. As Judge Schaefer pointed out, when a bankruptcy is filed, all of the debtor's assets are transferred into the bankruptcy estate. The 9th District and the Supreme Court has made it quite clear that once that interest is transferred, it becomes the sole property of the trustee. In Kovacs versus Thompson, the 9th District stated that when a cause of action becomes part of the bankruptcy trust estate, the debtor is divested of it, and only the trustee has standing. Only the trustee has standing to pursue that claim. And I don't think there's any dispute here that the trustee is the real party in interest and the party that had standing to pursue this claim. That issue is not disputed by anybody. But what is disputed is whether or not the plaintiff would have an opportunity to correct his lack of standing by substituting the trustee later on, or arguing that he had some auxiliary interest that gave him some interest or standing to bring the case. And the answer is he did not. The only way the substitution of the only way that the plaintiff could have had any residual interest in the case is if the plaintiff had disclosed the asset as part of the bankruptcy. The bankruptcy rules make it very clear that in order to have any interest in any exempt amount or in any excess amount, you have to disclose that asset in the bankruptcy. And then if the bankruptcy doesn't dispute it, or if there's a determination of what the value of the personal injury claim is versus the bankruptcy debt, then you might have an excess amount. But because the plaintiff never disclosed his asset in this bankruptcy, there is no residual interest. There's no interest at all. The law makes it very clear that that asset becomes part of the estate and is the sole interest of the trustee unless it's abandoned. So there's no residual interest. The plaintiff has cited some case law in his brief, namely the Reichert decision and the Young decision. And in those cases, the court had talked about having some residual interest and allowing the bankruptcy to substitute in and have it relate back under Civil Rule 17. But again, if you read closely in Reichert, it says that there was no dispute. There was no dispute that the plaintiff had an interest in any exempt amount. And that tells us that the plaintiff disclosed that asset as part of the bankruptcy. In addition, in Reichert, the civil suit and the bankruptcy case were pending simultaneously. The bankruptcy trustee knew about the asset. That's a distinct difference that applies here. The bankruptcy trustee didn't know about it. And it wasn't disclosed, so there's no way there could have been any interest in the exempt amount because the trustee didn't dispute or declare that there was an exempt amount. And there was no determination that there was any excess finding. So the Reichert case doesn't apply because in Reichert, the plaintiff disclosed the asset in bankruptcy and that didn't happen here. The plaintiff also cited Young in their brief, and again, it was the same thing. In Young, the court allowed the bankruptcy trustee to substitute in and become a party plaintiff to obtain standing to pursue the suit, again, because the assets were disclosed in the bankruptcy, and that didn't happen here. But what we do have is a case out of the 6th District where the case law is factually and legally on point with this case, and that's Shefkew versus Worthington. In Shefkew, the plaintiff was injured in a work accident. As part of his injury, he filed for bankruptcy. I shouldn't say it's part of his injury, but he subsequently filed for bankruptcy. His debt was discharged, and then he filed a personal injury lawsuit. And in Chef Q, the court found that the plaintiff, because he had filed for bankruptcy and didn't disclose the asset in bankruptcy, he had no standing to pursue the case. The court also discussed Civil Rule 17 and discussed why it didn't relate back to the original filing. Then the holding of the court, relying on Schwartzwald, was that unless a person with a real party in interest pursues the case, there's nothing to relate back to. So the court found that the bankruptcy trustee in cases where the court found that in cases where the party that originally commenced the suit did not have standing, you can't substitute and relate it back by bringing in the real party in interest because the person who originally filed it never had standing to begin with. So what we have here is Chef Q with the case that's on point. It's factually almost identical to the case before us. And the court determined that the plaintiff didn't have standing. You can't relate back under Civil Rule 17 because if you don't have standing to invoke the original jurisdiction of the court, there can't be a substitution of the real party of interest. And the court also found that there wasn't any residual interest that the plaintiff might have had because it was hypothetical or it was never disclosed, so there was no finding that there was any residual interest in any asset. The 9th District has also considered several cases involving substitution of the real party in interest in Hegraves versus Carter. In that case, the plaintiff again did not list their assets as part of the bankruptcy estate. There was no abandonment of the claim by the bankruptcy trustee. The court found that there wasn't any residual interest, and the asset remained under control of the bankruptcy trustee, and the plaintiff didn't have standing to bring the suit. That's Hegraves versus Carter in 1996. Had a similar ruling in Kovacs versus Thompson in 1997. So we have some authority out of the 9th District. We have authority from the Ohio Supreme Court, and we also have the Chef Q versus Worthington case, all of which discuss the issues that are presently before this court and urge this court to affirm the ruling of the trial court, namely that the summary judgment in favor of the appellees was appropriate because the plaintiff lacked standing to bring the case because all of the assets were transferred to the bankruptcy estate, and they remain in the sole control and of the trustee. There's no evidence that any of the assets were excess or exempt, or because those things can only be found if the asset is listed as part of the bankruptcy estate, and here it was not. Furthermore, because the plaintiff didn't have standing to begin with, either as the real party of interest or with any residual interest, Civil Rule 17 can't be relied upon to substitute the bankruptcy trustee as the party plaintiff because it was never properly commenced to begin with. The initial party never had standing, and under the Schwartzwald decision, you can't rely on Civil Rule 17 to relate back a substitution of a real party in interest when the party that first brought the case never had standing to begin with. So we would ask that the court affirm the decision of the trial court.
We have about 4 minutes remaining.
Good morning.
Right.
May it please the court. My name is Paul Morway. I'm here on behalf of the appellee Benjamin Campbell. I just wish to briefly follow up and supplement statements made by Ms. Bartow. She is correct that the interests are aligned in this case. Specifically, the appellants contend that the Schwartzwald decision has been clarified by later decisions. However, we respectfully submit that the subsequent decisions related more to collateral attacks, whereas this is a direct appeal. Therefore, they're not as applicable. In addition, the Schwartzwald decision stated that Rule 17 can't be used to cure a standing defect after the statute of limitations is passed. Here, there was no standing as the personal injury claim is not disclosed on the bankruptcy estate. Therefore, appellee Benjamin Campbell respectfully joins the appellees in requesting that this court affirm the decision of the trial court. Thank you.
Please report very briefly. My name is David Fignelli, and I represent the police, the Braves. And we would join in Ms. Bartow's argument on behalf of State Auto, our interest are aligned, and also point out that this circumstance where Rule 17 may be applicable in a situation like this would be a situation where someone has filed a personal injury claim before they file their bankruptcy. Then they file a bankruptcy. So they had standing at the time that they filed a personal injury claim. And in that situation, then after they filed the bankruptcy, they're no longer the real party in interest. There would be a proper substitution of the bankruptcy trustee after the fact. So that would be an appropriate case where Rule 17 would apply to substitute the real party in interest. That's not the case here. It's been argued at length. The plaintiffs' appellants did not have standing at the time they filed the suit, the personal injury suit, because they'd already given that up by filing bankruptcy and not disclosing. So we'd ask for an affirmance of the trial court's decision dismissing the entire case.
Thank you. We have around 4 minutes.
Essentially, what I've heard is, again, blending of the concepts of interest, real party and interest, and standing, and being used interchangeably by the appellees in this particular case. But what I also heard from appellees in this case is that there was an acknowledgement that there is a difference between the interest, real party and interest standards. And that came out in the attempts to distinguish Frygard and Young. In both of those cases, they said what made the difference in those particular cases is that it was disclosed to the bankruptcy trustee that the actual case was out there, that it was available to be put into the assets. So what they're really arguing is that because in this particular case, because it wasn't reported to the trustee, that there is no interest in this case. Not real party interest, that's not the argument here. The argument is that this party had no interest, and therefore Rule 17 could not go back, relate back to the particular case. So the question that has to be answered based on the argument from appellees is whether or not there was any residual interest in this case. Any residual interest that he had, despite the fact that he didn't disclose the information on his bankruptcy report. And again, what that's asking the court to do is decide something that's usually decided by the bankruptcy courts, whether or not there was a conscious attempt to deceive the individual, the bankruptcy court and the trustee by not disclosing it, or whether this was an accidental issue.
Is there a case law that says that he has to have deceived them in order to not qualify?
The judicial estoppel issue goes to that particular portion. I don't have that case law. It's been cited throughout this case, and there probably isn't the record, but judicial estoppel does not apply either in the bankruptcy court or in the state court if there was an accidental failure to disclose, if it was not an intentional. That doesn't change the real party and interest status. The trustee is still the really real party and interest on this.
I was going through the timeline, so, and I'm trying to figure out why he filed the complaint, personal injury complaint in April 2012. Deposition in November of 2012, where it was disclosed that the bankruptcy, I presume, came up at that time, I'm guessing that it did, probably the transcript. And then, but it wasn't until July of 2014 that the trustee moved to reopen the bankruptcy estate.
What had happened, that was after the motion had already been filed by the appellees in this case. They waited that time period, and then immediately after that was filed, we had contacted the trustee to let the trustee know that there was an action here. What happened in the deposition transcript, it was a very short question about, have you ever declared bankruptcy? And the individual responded, Mr. Kearney responded that he had declared bankruptcy, but he wasn't sure when. So I know we've heard that they had to ask for additional information or records to get the docket from the bankruptcy court, but the bankruptcy court line, the docket was online. That's something that we actually asserted after the fact as well. So the timeline, I guess to explain the timeline, the deposition, the bankruptcy occurred, he filed this complaint, the deposition was taken. Then almost 2 years later, the appellees in this particular case filed a dispositive motion to the court And then when the trustee was aware of the dispositive motion and was aware that this was an issue, tried to intervene. Because I'm out of time, unless there's any other questions, we would ask the court to reverse the trial court with instructions that the trustee should be allowed to substitute for the veteran's treatment advice.
Thank you. The court will take the matter under advisement and written opinion, it's easy for me to say, will be sent to both sides, to all parties, I should say. And in the interim, you can look on our website. Thank you very much.
Thank
you.